Can you sue a daycare for negligence in Ohio? Ohio daycare injury lawyer explains. Can you sue a daycare for negligence in Ohio? The short answer, yes. However, it is important to understand the legal definition of negligence as recognized by the Ohio courts. In this video, we will help you better understand what constitutes negligence, what factors to consider when determining liability, what steps you should take after your child suffers an injury at a daycare, and more. Want to find out if you qualify for an Ohio daycare injury lawsuit? Contact our firm for a free, instant online case evaluation today. Understanding a daycare's duty of care. Negligence in a daycare setting happens when a child care facility, its daycare owners, or daycare staff fail to provide the level of care required by law, resulting in harm to a child. Every daycare is legally obligated to maintain safe premises, supervise children at all times, and follow strict health and safety procedures. These requirements constitute the daycare's duty of care. When a daycare breaches that duty through inattention, unsafe conditions, poor hiring practices, etc., the law allows parents to pursue a negligence claim and hold the facility accountable. Common acts of negligence in Ohio daycares include leaving children unsupervised during outdoor play or nap time, ignoring state-mandated staff-to-child ratios, failing to inspect or repair broken toys, furniture, or playground equipment, hiring unqualified staff without proper background checks or training, neglecting to report accidents, illnesses, or behavioral concerns to parents, using harsh or inappropriate forms of discipline. When these acts of negligence result in a child's injury, the parents of that child could have a valid legal claim against that daycare. Common types of injuries and abuse in Ohio daycares. Common injuries and forms of abuse in Ohio daycares include broken bones and fractures caused by falls, rough play, or lack of supervision, head injuries from falls, collisions, or unsafe playground equipment, burns or chemical exposure from cleaning agents or unsafe storage of toxic substances, bruises or internal injuries consistent with physical abuse or aggressive restraint, choking or suffocation incidents due to improper food handling or unsafe sleep practices, emotional and psychological trauma from bullying, isolation, or verbal mistreatment by staff or other children, sexual abuse or inappropriate contact by unmonitored staff or older children, neglect leading to dehydration, malnutrition, or untreated illness. Many injuries that facilities describe as accidents could have been prevented with proper supervision and compliance with Ohio's safety standards. A pattern of repeated injuries or missing incident reports often indicates deeper problems within the facility's management. Families who suspect daycare abuse or unsafe practices should document their concerns and seek medical evaluation for their child immediately. Does biting count as daycare negligence? Daycare injury lawyers are often presented this question. The answer is no. Generally, biting does not constitute a daycare negligence claim. If a child bites another child, even if that bite results in injury, it doesn't likely justify legal action. However, if there is documented evidence or a history of one child biting another, or multiple children, and the daycare failed to mitigate the situation appropriately, there might be grounds for a claim. Additionally, if staff failed to respond adequately to the biting incident, then there could also be grounds for action. What are the warning signs of daycare negligence and abuse? Parents know their children best, and subtle physical or behavioral changes can be the first indication of a problem inside childcare centers. Warning signs may appear gradually. A once active child becomes withdrawn, fearful, or anxious about returning to daycare. Physical indicators such as unexplained bruises or poor hygiene may point to neglect or abuse that staff members are trying to hide. When an injured child shows signs of trauma, discomfort, or inappropriate sexual knowledge, it's critical to act quickly and report concerns to authorities. Common warning signs include frequent crying or intense fear at drop-off or mention of the daycare, flinching, sudden movements, or fear of being touched, unexplained bruises, scratches, or repeated minor injuries dismissed as accidents, persistent soiled diapers or evidence of unsanitary conditions in the facility, noticeable weight loss, fatigue, or reluctance to eat or use the bathroom, regression in behavior or speech in a previously confident or active child, knowledge or discussion of sexual behavior inappropriate for the child's age, Recognizing these red flags early can prevent further harm and protect other children from the same dangers. Claims against public versus private daycares in Ohio. The process of filing a daycare injury claim in Ohio depends on whether the facility is privately operated or publicly funded. Private daycares. Private daycare centers are typically held to standard negligence principles. If a child is injured because staff failed to follow safety rules or state child care regulations, the facility and its employees can be held directly liable in civil court. Public daycares. Public or government-operated daycares, such as those run by school districts or municipalities, fall under Ohio's Political Subdivision Tort Liability Act. This law gives public entities a form of legal immunity, but several key exceptions apply. Immunity may be lifted when an injury results from a physical defect on the property, such as unsafe playground equipment, broken furniture, or other hazardous conditions that the public entity failed to repair. Victims can pursue claims if the injury was caused by negligence in maintaining public buildings used for governmental functions. Although claims against public entities are more complex, they are not impossible. An experienced attorney can identify which category the daycare falls under and whether immunity applies. What if I signed a waiver of liability with the daycare? The Ohio Supreme Court ruled that pre-injury waivers signed by parents for-profit childcare centers are, generally, not valid. A commercial daycare facility that accepts payment for supervision cannot use a waiver to escape responsibility for negligence, reckless acts, or intentional harm. What if the daycare denies responsibility? It's common for daycares and their insurance companies to deny fault after a child is injured, often claiming the event was accidental or unavoidable. However, a denial does not mean the facility is free of responsibility. Contact an attorney to get a free, professional evaluation of the incident. How is negligence proven in a daycare injury case? There are 4 core elements that the plaintiff must prove in a daycare case. 1. Duty of care. The plaintiff must show the defendant had a legal obligation to act with a certain level of care. In a daycare injury case, the plaintiff must reference specific laws, statutes, regulations, and terms to establish that the daycare had a duty to care for the child. 2. Breach of duty. The plaintiff needs to prove the defendant failed to meet that standard of care. In a daycare injury case, the plaintiff must provide evidence that the daycare either failed to act according to their duty of care or acted maliciously or intentionally to cause injury. 3. Causation. This element connects the breach to the injury, showing the defendant's action, or inaction, was the direct cause in fact and proximate cause, of the harm. You must show that the breach of the duty of care resulted in the child's injuries. 4. Damages. Finally, the plaintiff must prove that the child suffered actual, quantifiable harm, such as medical bills, pain and suffering, mental anguish, etc. What to do immediately after a daycare injury? When a child is hurt in a daycare setting, parents often feel panic and confusion about what to do next. Taking quick, deliberate steps can protect both the child's health and the strength of any future legal claim. It's important to focus on medical care first, then gather information that may later prove how the injury occurred. Following these steps can help families respond effectively and begin holding the daycare accountable. 1. Seek medical attention immediately to document the child's injuries and receive proper treatment. 2. Request a written incident report from the daycare and keep a copy for your records. 3. Take photographs or videos of the injury, the scene, and any unsafe conditions. 4. Avoid speaking with the daycare's insurance representative until you've consulted an attorney. 5. Document all communication with daycare staff, including dates, names, and statements made. 6. Report the injury to the Ohio Child Licensing and Quality System, OCLQS, if the harm was serious or you suspect neglect. 7. Contact a personal injury lawyer who has experience handling daycare negligence cases in Ohio. How long do I have to file a daycare lawsuit in Ohio? Note, the following is not a guarantee of your statute of limitations. In Ohio, most personal injury claims, including those involving daycare negligence, must be filed within 2 years from the date the injury occurred. When the victim is a child, this time limit can be paused, or tolled, changing the statute of limitations. In cases involving wrongful death, the statute of limitations is also 2 years, beginning on the date of the child's passing. Each case is unique, and there are a number of factors that can affect your statute of limitations. Contact Piscitelli Law Firm for a free consultation to determine your exact statute of limitations. What is the legal process for suing a daycare in Ohio? While each claim is unique, most daycare injury claims follow these general steps. 1. Initial consultation. Meet with a personal injury attorney to review the incident, evidence, and potential claims. 2. Investigation. The attorney gathers records, witness statements, and inspection reports to establish negligence. 3. Filing the claim. A formal demand is sent to the daycare's insurance company or a lawsuit is filed in court. 4. Discovery. Both sides exchange evidence, including medical records, staff files, and safety documentation. 5. Negotiation and mediation. The attorney works to reach a fair settlement without unnecessary delay. 6. Trial preparation. If settlement fails, your legal team prepares to present evidence before a judge or jury. 7. Verdict or settlement. Compensation is awarded through a court verdict or agreed-upon settlement, providing financial relief for the family. How the Piscitelli Law Firm helps families. The Piscitelli Law Firm represents families across Ohio who have suffered due to a daycare's failure to protect children from harm. Our firm investigates every detail of an injury or child abuse allegation to uncover exactly what went wrong and who is responsible. We review inspection reports, staff records, and surveillance footage to determine whether the daycare violated safety laws or ignored clear warning signs. Frank Piscitelli personally guides each family through the legal process, explaining their rights and options in clear, practical terms. Because Ohio's statute of limitations restricts how long families have to file a claim, our firm moves quickly to preserve evidence and secure witness testimony before it's lost. We handle communication with the daycare's insurance company and opposing counsel, allowing parents to focus on their child's recovery. Every case we take is built on compassion, diligence, and a commitment to obtaining full and fair compensation for the harm done. Through accountability and legal action, our law firm helps families restore their sense of trust and protect other children from future negligence. If your child was injured due to a daycare's failure to provide proper supervision or safe conditions, contact the Piscitelli Law Firm for a free consultation today. We'll listen to your story, explain your options, and fight for the justice your family deserves.